Council Pokome Ewa Homa. Council to make a good morning.
Good morning, I'm from saying.
Eradiadum, now one sorry.
Very
well. I don't pay you that said, now your friend one, it's in the theatre, no, and the air cost of Brashe Bedjem. Ura James Jaquason, Assin North, Brashe Bedjani, no matters arising with his position as a member of parliament. And the entanglement, as they say, will go through with legal battles near there. Ma yentio, as we speak, and we were told, sir, 2 registrars from both the Supreme Court and the High Court, and the James Jaquason, now one more to me as 7 a rate of someone if we both courts no and I don't pay a year because one much moment who baby MP no wafa. The position is it at threat?
I don't think so. I'm saying this because it is the Speaker of Parliament who will make a determination. Say he continues to be recognized by him as a member of Parliament or otherwise. Obekaya, last year, I think around September, thereabouts, there was a letter that the Speaker wrote to the Registrar of the General Jurisdiction Court, or Accra, and he copied that letter to the Registrar Cape Coast and also to the Judicial Secretary. Now, letter in free, it was in response to a letter in Free High Court, Cape Coast Court, indicating that judgment has been given against Yura Kessben. The Speaker will have to declare Nisi vacant to that effect. The honor on also a choice. He, as the Speaker, cannot do that because he also has been served with letters and the processes indicate the said Assin North MP RCK appeal in respect of such judgment Yamano or file a stay of execution. And to that extent, anything now, no be or Parliament or will be sub judice. That is, he will be meddling with issues of the court until the issue is finally determined at the court. He was unable to declare the said seat vacant. And he said, undeclare that seat vacant, it will therefore mean that whoever is occupying that seat, for the time being, I'm using the word for the time being advisedly, for the time being, it has the right to be there. This is a determination now. Speaker now here through letters or the Registrar General Jurisdiction Accra to the Registrar High Court, Cape Coast, and then copy to the Judicial Secretary. And talking about threats, I don't think so. But definitely, if there are these court registrars who are looking for him to serve him with some of these processes, well, that is okay. But I find it a little bit curious because when it comes to some of these things, they have to be said by bailiffs. Of course, these bailiffs do this work for and on behalf of the registrar. But it is not because the court might have specifically, and I don't know that the court probably will go to that extent. It is not the court might have said the registrars will have to do this service personally on these persons. Now, there was something that was said at the, at the Supreme Court. Now, there was this issue about procedure, as I say, not several a process on a sitting member of Parliament. Now, that particular process, went to hit a snag because the Speaker is not immediately within the jurisdiction. I find that one a little bit curious as well because the Speaker really don't want Dipa on Ujira and Nemu a first deputy speaker. And so that technically, he could receive whatever processes from the courts, and then he will now proceed to serve same on the member of parliament. But I am now told, he said, because a speaker, back when he knew, the people are saying they wouldn't collect the letter. They should wait for him to return before that thing is done. I find it again a bit befuddling. In politics, society might be brave, and we should be very careful because we are doing lots of things, for our political experiences. Or people will be making references to them and will be in trouble. And I'm saying this because the speaker no any honor or no act in his stead. If the speaker is there and the first deputy speaker is there, why is it that somebody at the parliament house, the clerk of parliament or whoever it is who says, I will receive that letter or that service of the process of the court? Speaker Babi Embransa. I find that quite curious. That you create friends and monsters out of these small things that we are doing. So, as I said, because of this process, I will find it a bit difficult to use parliament to set the process on him. The court is saying, okay, fine. If you cannot serve him in his capacity as a member of parliament because of this process here, then serve the thing on him as an individual, personally. So what I make an answer, which would then mean, it will not require any of these parliamentary procedures, for same to be served on him. Now, I overheard a particular member of parliament and the lawyer at that saying, to the extent that the court has said that they should serve the thing on him as an individual. The court has, by that said, they don't recognize him as a member of parliament. That is not what it is. Because the first one said he was going to be serving in his official capacity as a member of parliament. So the court says, well, as a way of ensuring someone's canon, won't serve it on him personally. Now, if these people make all these attempts at Omonyana, they are supposed to go back to court, move a substituted service, move a process, substituted service, by which they will now make a publication in graphic, have some even pasted at Mr. Tukwitin's house and any other place that he didn't say. It be to me, I bring to his notice. And if it doesn't come, the court can go ahead and do that. Until we are making so much of a meal. So you see, the friends and the registers are going around as if they are combing through the whole of Accra or the whole of Ghana looking for him. They know what to do. You are supposed to go to Parliament, you don't find him. Fine. You are supposed to go to his house, you don't find him. So you are supposed to do that 3 times. If you do that on 3 occasions, that's a Wansankanoa. Then of course you file proof of non-service. And then you file this process for the substituted service, and that will be granted by the court, and then they proceed with the rest. But we are creating some needless tension when people know very well. I don't know more here, no. I hear some people even in Parliament saying that they are going to ensure they will stop the Assin North member of Parliament, from participating in any processes in the House.
And also na me basis here because concerns Article 94 clause 2, a person shall not be qualified to be a member of Parliament if A, he owes an allegiance to a country other than Ghana, and B, has an adjudgment, or otherwise declared 1, a bankrupt person under any law in force in Ghana and not being discharged, or the 2 to be unsound minded or detained as a criminal lunatic under any law in force in Ghana. And these are the provisions of Article 94 clause 2. Now the big question is the debate, any argument, and it's at the time of filing his nomination at the EC head office, na enya dia ya granting a certificate to denounce ne citizenship with Canada. And for that matter, he cannot say, even though now we're beginning with the process, but we bet me a contest at the time our certificate the Canadian government ending to Musa would denounce the citizenship. He is still considered as a dual citizen. He wasn't qualified enough to become a member of parliament and even contest in the first place.
Okay, that is also where we have some little problem. Is oath of allegiance and now pledge allegiance to another country, who terminate with citizenship. When you look at the constitution doesn't say if the person is a citizen of another country. I hope you understand what I'm saying.
Yeah,
what the constitution says is the person should not owe any allegiance to any other country. So what is an issue? Very wrong. Is for them to have now produced documents and other things that the gentleman owes an allegiance to another country. This citizenship does not necessarily mean that he owes an allegiance.
Because owing an allegiance to a country will mean what? At the end of the day, constitute an allegiance owing to a country.
Good. So, who owe allegiance to another country? And only say, of course, you have sworn to pay taxes. You will serve even at the peril of your life and things like that to the country in issue.
But I am a machine number mukakra.
Sorry. Yes, sir. Oh, can't I say? Adibia, as I say, a year or minimum. A bema or manesi or to say be a 2 and that's a be a basse a beer, Bibiaba, or minimum. I say a point here. I know over to me, Apple at Ato, Sasania Cano. So, what will?
Yes.
Okay, can't answer. And then, of course, who citizenship will also be granted you. But it is not, you believe from the same kind of, they are. You always have to, for instance, swear an oath of allegiance and sign Yamao citizenship. No. There are certain cases that it can be waived. What one will have to check is whether or not Kessben also swore oath of allegiance in respect of the country called Canada. Now, when yes or what a citizenship of Canada, because it is possible that he has a citizenship of Canada, but he had a waiver. One swear allegiance to Canada. I hope you understand what I'm saying.
Me too, Parkinson.
Yes. So those are the issues, because you see, whatever the Constitution wants to say, it will state it clearly, and that's the reason for which the lawyers for Kessben, I can't say. We are beginning to make you look as if citizenship is the same as owing allegiance. Let's go to the Supreme Court. That Supreme Court, in the case of Ghana, actually we say, so who allegiance to another country that gives you citizenship, and that's a we are citizen of a certain way, because when you are not a Canadian, nothing. Who be Canadian citizenship, that amounts to naturalization. So that can I say?
Okay.
It can be through marriage, if you are worried or baby or a Canadian. If you worry, say or a Canadian, naturally, also by a Canadian, right? If be a no by a Canadian because of a heredity, I can say, well, I will refuse to swear any allegiance to Canada. So they were supposed to have gone to the Supreme Court for the Supreme Court to make a determination as to whether or not Yekase will be a citizen now. It is the same as Owe allegiance. And now say Owe allegiance now Yaka Awo a friend saying Constitution Limono a year meant to talk about citizenship. And this was refused at the High Court. The High Court also a rule here in respect of this particular matter, and I declare a friend saying that they can say he was wrongfully elected. It is only appeal no NSA because the High Court didn't make reference to this issue of Article 94(2). and I proceed to give judgment in it,
Okay.
That judgment, a nullity. And that is what he's appealing at the Court of Appeal. Right?
Mm.
And these processes are before the court. Once he has been sworn at the how do you call it, at the parliament. Or a member of parliament, Once he now moves this application about sale of execution and other things, it means that the status quo ante should remain. Whatever he was enjoying, whatever he was not enjoying, it should be the same situation until the court finally makes up the determination. I hope you understand what I'm saying.
Yes, I do. But the question is, already Cape Coast High Court passed a judgment, even on the eve of swearing in the members of parliament. And such judgment was brought to his attention. Said this is the judgment a free Cape Coast High Court abba. And for that matter, SSN excusing without he being sworn in. And now the other argument, is once there is a judgment, until say a appeals court, overturning the judgment of the High Court, that High Court judgment will still stand.
No, that is not the argument. You see, there is currently a motion for stay of execution.
Okay.
When you are talking about stay of execution, it is saying whatever judgment that has been given in respect of a particular matter, she is suspended. That is what it means. Any process ever flow from it, it should be suspended. That is what is meant by stay of execution. So yes, the Cape Coast High Court has, made a judgment to say, election, was not appropriately done. But meanwhile, he has also filed stay of execution in respect of that judgment.
Okay.
So one cannot come and tell me, because the Cape Coast High Court has made appeal. Yes, notice of appeal, and now just being at the Court of Appeal simplicity does not amount to stay of the third judgment of the court. But you are supposed to formally file a stay of execution. And that is what they have done.
But because stay of execution, and what time limit now?
Nobody knows. Who files a stay of execution and stay of now within about a year, you are a bit indolent. You understand what I'm saying? You will have to. Your application, say now will have to be determined. But of course, there is the application for the stay of execution, and what the grant of the stay of execution. When the stay of execution is granted, it is not time tied. What it means is that the particular thing now, during that time now you stay execution, that thing will be done. Not the next court at the top, then of course, who stay of execution, will now not hold. I hope you understand what I'm saying.
I see.
But
for now,
another. Then there's also the other issue in respect of self. One filing a notice by way of an application for stay of execution. Right? I am not very sure about this, but it appears to say what is before the Supreme Court currently, or at the Court of Appeal, an application for stay of execution. In the meanwhile, young practice, actually say, once there is any notice of any such application, the parties must stay at bay, because at least there is the indication that this is what he intends to do. So even when it comes to things like, say, if you're applying for, say, an interlocutory injunction, just applying for that interlocutory injunction, until it is even determined for the injunction to be granted, or for it to be determined for the injunction to be refused. Once you are served with a copy of that application indicating what the person intends doing, our practice is that you hold your horses till the court make the determination. If say question or file any motion for stay of execution, now that is enough to restrain all parties in proceeding to do any other thing. I hope you understand what I'm saying.
Me too,
because what the member of parliament, the lawyers, a person by the High Court in Cape Coast for the interpretation of Article 94(2), and which was refused. Of course, it was opposed by these persons, right? Say the court should ignore it. Now, the irony of it is that this very person or can't say, opposed to that particular interpretation, No, only as the Supreme Court to say, of an interpretation in respect of that particular article. So it is telling you of a certain double standard here. That's also one pencil. Now, actually, and then you have now gone to the Supreme Court and you are asking the Supreme Court to give the interpretation in respect of that particular article.
Okay, because my entities here were not yet clear in our minds. Sir, the council and I said the lawyers of a year Urua Jachikwesi defendant, one more moving motion or application for a stay of execution. That's a court to know ain't here that particular application now. Does it really take an effect just for the mere was serving notice of a stay of execution?
Yes, and I can say by practice, that is what it amounts to.
Okay.
By practice, that is what it amounts to.
Okay.
There are two schools of thought to say, well, you have only evinced your intention. What training your officer over here? Court to know far more here. If you do the NFSA and the BCMI. And then there's another school of thought which already say, once any chrono, one file application, can court to know a determination of that application now. That's a that they are no matter what. But by practice, it's not American. Once this particular application is filed, the parties concerned wait till the court makes a determination on the matter.
Okay. And no crano, and ya dear court both parties in argument. And some appeals court and so about another appeal application against the High Court ruling, if I'm right.
Yes. So those are the issues. Those are the issues. If for nothing at all, there is this application now. There is this application before the court. Once that application is before the court in respect of the motion for the stay, that will have to be determined. And that motion for stay of the issue is before the Court of Appeal. And I am told, subject to unique, I'm told they said those things were refused. So if they were refused or the right to go beyond the Court of Appeal, and that is to repeat it at the Supreme Court.
The state of execution,
right? Yes, you repeat it at the Supreme Court. And the Supreme Court will not say the amount date. The Supreme Court will not give you a date that you be here some particular matter. So I don't know whether or not the Supreme Court has given the data on the court now agreement in respect of that particular application for the state. So to the extent that those processes have been filed with the court, as I said, as part of yen practice, parties involved are to just restrain themselves.
I see. I think in that sense, because for the last 1 year, I feel Any Yetuaneka, and then again, Mrabebre Honoma, including the 2022 budget. Nino, what to about Amaya passe and the Sadia Banina. They say a say of execution motion, no Yenya NTA, left alone the appeal on a year. The judgment because High Court had the by Yenya NTA and also at the highest level of the court, you know. Still now, no obey me a cranny home. Abonebo said, well, no, that's why I'm Rashid.
He can go to Parliament, exercise his function as a parliamentarian, and nobody can stop him. And now, Mr. Say, you will attach I can say, if he should come, they are going to stop him. He will bring it to the attention of Mr. Speaker, which is currently the first deputy speaker, no? And tell the court, tell the friends, the speaker say there's a stranger in the house, and he should be go out. I'm sure he might have probably forgotten the letter that the speaker, that's Mr. Babin, actual in respect of this. So, friend then, your wife, who will now be acting as a speaker for and on behalf of Babin, cannot set aside what Babin has already said and written even to the courts. I hope you understand what I'm saying.
Metiopa.
If you know, say, articles in court, Parliament. Not any member of Parliament raising the issue that he's a stranger. Not in the unlikely event, say, your wife, and I expect him to do the needful. Your wife, it decided, say, this application has been made on the floor of the house, and he is going to grant it, and as it were, ask the marshals to walk him out. I'm telling you, you're going to see the worst that was before the Xmas. You see, when you're talking about hooliganism, I thought they are not for 40 minutes. If you're talking about hooliganism, the hooliganism starts from the one who is provoking somebody to undertake that hooliganism.
Because Matthias,
let's seize this opportunity because I thought the Ghana politicians, I will use certain expressions if you know the way I'm doing. And then I say, we say, so the baby to baby. That's what I'm finding on a heading. If you talk, if you know what you are going to do is illegal, then if I call him, say you may try to use the formality that are supposed to be there, because you now have your wife who happens to be an MPP person. And from all the indications that we are having now, it does not make one not to believe, say, what is being done now is an agenda setting. Because also what the guy can say, this particular member of Parliament has participated in almost everything in Parliament, including passing of laws, including receiving his salary.
Yes.
So what is it that has all of a sudden changed? And Minty, Obi can say, Wallahi will make sure say my papa enter the house with him. You see, so those are the issues. And as much as possible, making sure say quiet near ma and because you were saying the account team so be paper. So don't let anybody make any attempt. And I'm saying say there are various processes in which you at the issue and back to a head. If question doesn't go, the Supreme Court will issue a substituted service indicating the return date. They will proceed to do whatever they are supposed to do at the Supreme Court in its absence. And over there, the Supreme Court interpreted what's the name? I interpreted the issue of Article 94(2). That's what I say. Allegiance, the same as citizenship. Then, of course, Abonatum.
Okay.
Right. And they can even proceed to make the consequential orders to say, because of this, the Supreme Court, we are saying, as a member of Parliament. In that case, that letter noir back in HR said he was waiting for the court to make a determination and that he cannot ask this man not to come to court, otherwise he would have been prompting or acting in contravention to what is before the court, then that particular letter wouldn't hold because the Supreme Court will have said that the man is no more a member of parliament.
All right.
But until then, no.
Yes,
yes, but until that determination, back at the courts, but of course at the highest court, he remains a member of parliament.
Okay, that's all. But I no pay. Okay, I say lawyer Paul Kume, a private legal practitioner, and Yanino Edin Kobono. Mami Chame Hong Kong,